Kong, we still have the common law collection of torts that would come to the aid of anybody complaining of an intrusion by a private individual, whether that's a neighbour or an employer. That would include a claim in tort for breach of confidentiality. So if there was a legitimate expectation that a confidence would be observed, that information would not be disseminated, and that legitimate expectation was one that was breached intentionally by the other party, such that information was put into the public domain that should not have been put in the public domain, then the individual would have the common law right to pursue a claim for damages for breach of confidentiality. Similarly, there is a right to prevent people coming onto your premises, of course, and that right is given recognised effect through a right to claim damages for trespass to premises. What is interesting with the PJS decision, however, is a recognition that the jurisprudential underpinnings of these types of claims has shifted slightly. So in the past, as was very clear from the spycatcher litigation, the focus was very much on whether or not there was an issue of confidentiality, whether there had been a breach of confidence, and whether or not the information concerned was already in the public domain, such that it was futile to allow the injunction to proceed. The decision of Lord Mance in the PJS decision makes it very clear that, as I say, there has been a subtle shift in approach, namely a shift away from questions of confidentiality and futility and public domain towards a more personal inquiry into whether or not there has been an intrusion of privacy. In the interest of completeness, of course, there are other causes of action available, recognised traditional tort causes of action such as breach of copyright, malicious falsehood, defamation, etc.